How can do-it-yourself estate planning harm your family? There are quite a few ways, and I will discuss a few of them now. I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. And the first way that it can hurt your family is actually costing more. Often when DIY wills and DIY trusts walk in the door, there are questions about whether they are valid, and time and research that cost money has to be put into figuring out if these documents actually had the effect that you intended. And of course, at that point, you've actually passed away and we can't fix anything. And then we present them to the court, who also has questions, and that's more time and money trying to figure out what's going on. And then maybe it isn't legally valid, not enough witnesses. Maybe we can't find the witness and there was no notary. And suddenly, instead of having your spouse inherit everything, your spouse and your children are splitting everything. This isn't what you wanted, but this is what happens in Georgia when you don't have a will. And speaking of children inheriting, what happens when your children who are minor children inherit? Suddenly, there has to be a conservatorship set up by the court. It would have been better for you to have chosen who should be in charge in your will, set up a trustee. And what if it's real property? Suddenly we have a minor child on the title to real property, and we're going to have a whole lot of trouble selling it or doing anything with it without a court okay before that child turns 18. On top of all this, a lot of times do-it-yourself documents don't cover all of the possibilities. And so anytime there is ambiguity, it can lead to family fighting. It's easy to think that my family loves me and they will follow my wishes, but anytime you don't have legally binding wishes in place, it can lead to quite a problem. Lastly, sometimes it just doesn't get done because estate planning isn't something you want to do while you're relaxing over a weekend, and it just never quite happens. And so, of course, we're back to the no estate plan at all situation. So these are some ways that do-it-yourself estate planning can actually harm your family rather than helping it. If you've got more questions about estate planning, please give me a call. And I would also love to have your comments. Thank you. Can I draft my own will? Sure. But I'm going to give you some reasons that you should not. I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. And once I got asked this question by an attorney friend of mine. She didn't practice estate planning, she did other things, and she wanted to know, could she draft her own will? And my response was yes, if you know what all the words mean. So if you understand it, you can draft your own will. She pretty quickly agreed that she did not understand it and needed help. Please don't try this yourself unless you actually understand what all the words mean and what you are doing. One of the biggest problems is that people think that they have drafted something legally binding, and it is not. You get into my office, and it's not you, it's your family members after you've passed away, and there's a piece of paper that doesn't have enough witnesses, or it doesn't have a notary, or it's lacking other things. And your family members, first of all, have to spend money and time trying to figure out if this piece of paper is legally a will. And then there may even be extra court and attorney's fees while we're trying to probate this will, because the court has questions. We need to find those witnesses and get them to sign something saying that, this was in fact a will. Another issue is that it may not have the effect that you intended. Quite regularly, I see documents in my office where there is a will or even a do-it-yourself trust. And then later, there's another document that's perhaps a will that claims to modify the trust. This doesn't work. And sometimes we have an amendment to a will that doesn't have the right number of people signing it, all sorts of different problems. So signing a new piece of paper, saying something different, may not actually make the changes to your old plan that you think that you were trying to make. Do it yourself, not a great idea unless you actually know what you are doing and understand how each of these things works together. Wills and trusts interact differently. Everything in estate planning depends on who owns it. So is it in your probate estate? Is it owned by your trust? Is it life insurance that's going straight to beneficiaries? So if you don't understand all of the legal implications of those things, you may be making a bigger mess for your family. So if you've got questions about estate planning, please give me a call. And if you want to comment, I'd love to hear from you. Thank you. In this video, we are going to discuss the dangers of do-it-yourself living trusts. Obviously, you can do almost anything on the internet these days, and trusts are one of them, but should you? And what are the risks? I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia, and also the author of Peace of Mind Through Estate Planning. What are the actual risks? And the first thing to understand is what could go wrong in a trust generally. And I think there are two basic categories. The first one being that we didn't create the trust correctly. It wasn't signed correctly, or things weren't transferred into it correctly. For whatever reason, it is not a complete active trust. So in that situation, it's just like you never created the trust, except possibly worse if you've got something half transferred into a trust that doesn't exist. That could be more difficult to unwind. But in general, it's just going to be like you didn't do a trust at all. So you're not achieving whatever your goals were for the trust. And undoubtedly, you do in fact have a reason and a purpose for putting something into a trust. So that's option one. We think we have a trust and we just don't. Option two is that you do put the trust in place completely. It's just that the provisions of the trust don't do what you want them to do, whether that's not accomplishing something from an IRS perspective, or whether that's incorrect provisions for the trustee so that money isn't coming out or going to the right places at the right time. Whatever it is, the trust is not actually structured to achieve your goals. So those are the two possibilities. We might not have completed a trust, or we might have a wrong trust, as it were. And either of those is going to cost money. We're going to have attorney's fees and probate fees. This is going to cost real dollars to fix. Another issue around that is going to be that usually we don't find out about the problems until it's too late to fix them. Somebody passes away, we can no longer amend the trust or put their assets into a trust. And so often you don't find out that there is an issue until too late. Those are the dangers, and here are some reasons that you should consider not doing that. The first one being you're not receiving advice. So you're not receiving advice on making sure that it's set up correctly, that you've got the provisions that match your goals, that match your circumstances. In general, these trusts are the names of the people in charge, who gets what, and when, basically. So it's going to be gifting provisions or monetary use provisions, but the rest of everything in that trust is generally not something that they let you choose. So you are not getting anything customized to your situation. You're not getting something customized to your family and your goals. You're getting their boilerplate provisions that they have decided are the most inclusive to work for everyone. This is probably not going to be a best case scenario for you. Another thing to look out for is, of course, you're going to customize it with special instructions to the trustee. And what you're going to get is a blank space for you to type in special instructions to the trustee, which is great, except you might have a little writer's block. But when you put your words onto the paper, you need to be sure that they are covering all of the options and they make sense to someone other than yourself. They are legally binding. If circumstances change, perhaps we say, if X happens, do Y. We need to know, what if X doesn't happen? What if W happens? What happens then? Is that covered? Are all of the options provided for? So when you're doing, do it yourself online, you don't know if that's true, if that is the case. And of course, back to the idea that we don't find it until it's too late. In my practice, I have dealt with do-it-yourself trusts, do-it-yourself wills, do-it-yourself LLCs, all of these things after someone has passed away. And generally speaking, it is much more complicated to unravel than a trust that was put together by a competent attorney who gave good advice and helped the client put the correct things into the trust in the correct way. So it can cost time, money, headache, and just general stress for family members after you pass away if this was done incorrectly. Thank you for taking the time to listen, and please follow me for more information. DIY second marriage inheritance issues. What kind of things do we run into when people do their estate plans themselves? I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. And here are a couple of the things that I see quite a bit. And the first one is not considering a prenup. Of course, a prenup does many things, but it doesn't mean that you don't love someone. It doesn't mean that you don't trust someone. It just sets some expectations. And from an estate planning and inheritance expectation, usually what it says is, my stuff is my stuff, your stuff is your stuff, and we don't have claims on each other's stuff when we die. Now, this does not mean that you cannot leave things to your spouse in your will, but it does mean that they can't grab pieces of it that you didn't intend for them to have, because we've got the prenup that says legally you can't do that. You have waived your right to do that. The next issue with DIY a second marriage inheritance is forgetting to update those beneficiary designations. If they have not been updated since your first marriage, if they have not been updated since your children became 18 or older, if they haven't been updated to reflect trusts that you've put in place or anything else that has changed, it is likely to throw your plan completely off kilter. The last one that I see, and this one causes a lot of friction, is leaving the new spouse in control of money for children from your first marriage. You love your new spouse. You trust your new spouse. And sometimes it has been an incredibly well-blended family. Your kids get along with your spouse. Everyone is very happy. But often it leads to a lot of friction when someone who is not my parent is in charge of the money that my parent left for me. And there can be questions about, are we trying to save this money for the spouse? Are we trying to, when should the children get it? And we want to make sure that if you leave someone in charge of money, it's someone who is well positioned to be fair to everyone. So you are often not going to want to leave your second spouse in control of money left for children of your first marriage. That can cause tons and tons of issues. If you have more questions about beneficiaries and other inheritance issues with a second marriage, I would love to answer them. And please feel free to also comment. Thank you.